This is Left Voices for Friday, March 21st, 2014. I'm Andrea Sears. Tonight,
we have NYPD reports that actually say, yes, we're going into the Syrian community, but we're not interested in Syrian Jews. We're going into the Egyptian communities, but we're not actually interested in Coptic Christians. We're interested only in Muslims.
a challenge to NYPD spying on the Muslim community goes to the appeals court. A group of New Jersey Muslims has filed an appeal of a federal district court's dismissal of a lawsuit challenging the discriminatory New York Police Department spying program that targets innocent American Muslims based solely on their religion. The secret program was the subject of a Pulitzer Prize-winning series of articles by the Associated Press. The surveillance included infiltrations, videotaping and photographing individuals in gatherings, and recording license plate numbers. In New Jersey alone, the NYPD spied on at least 20 mosques, 14 restaurants, 11 retail stores, 2 grade schools, and 2 college Muslim student associations. In June 2012, Muslim Advocates, a national legal advocacy and educational organization, filed the lawsuit called Hassan versus City of New York, and the Center for Constitutional Rights later joined the suit as well. The city filed a motion to dismiss the suit, and on February 20th of this year, without oral arguments on the case, Federal District Court Judge William Martini issued a 10-page ruling granting that request.
The appeal gives us a chance to challenge what I think are a lot of the misguided views of the NYPD's Muslim spying program.
Glenn Katon is the legal director of Muslim Advocates.
People say, well, how are you going to find Muslim terrorists without watching Muslims? And a lot of things that we think the trial court mistakenly bought. There are 3 cases pending right now that are challenging the NYPD spying program. This is the first one that will go to a court of appeals. And we think that the Court of Appeals has 3 judges as opposed to 1 and fewer cases. And we think that with a more thorough analysis and a more detailed view of the facts and the law, that the court will find, if we prove our allegations of the discriminatory police practices, which we think we can do, that would violate a few different provisions of the Constitution.
I found the ruling in this case to be remarkable in that the judge basically seemed to be saying that there was no harm inflicted on the Muslim community except by them finding out that they had been under surveillance. What's your response to that?
Yeah, that is one of a few aspects of the ruling that I find very disturbing. I have 2 big problems with the particular part of the opinion that you just referred to, that the harm was really inflicted by the Associated Press by reporting the surveillance and not the surveillance itself. The biggest fallacy in that reasoning is that the city itself very publicly embraced and defended the spying program after the news story broke. So even if you accept what we think is a faulty premise, that it was the exposure by the AP that caused the harm, when you have the chief of police and the mayor of New York saying, yes, basically, we need to spy on the Muslims to keep the city safe, and all of these sites that we spied on are potential leads for criminal activity, then that does an enormous amount of harm, irrespective of whether it was the AP that first broke the story. But even if the NYPD, when asked to comment on the program, had given the answer that the federal government gives sometimes, which is, we will neither confirm nor deny the existence of such a program, still, it's the underlying act is unconstitutional, regardless of how it came to light. The Watergate break-in was not illegal because the Washington Post broke the story. It was illegal because it was an illegal activity. And the same is true for NSA spying if the day comes when that is found to be illegal. It's the conduct that is the problem. It's not the exposure.
What is the basis of the appeal? Where are you saying that the opinion is in error?
Well, basically, the court dismissed our case on two different grounds. One of them was that the plaintiffs don't have standing. They were not injured in a way that the Constitution recognizes. Part of that was, as you said, that it was the AP's reporting that caused any harm, and we are appealing that. The court also said that we did not state a claim for a constitutional injury, which is basically like saying, even if everything you said is true, the Constitution wasn't violated. And the court relied on a Supreme Court case that involved very different facts, where they were focusing immigration enforcement efforts based upon country of origin. And the challenge was, hey, you're persecuting us because we're Muslim. And the court said, well, if you're going after people from these countries of concern, and those countries of concern are predominantly Muslim, then it stands to reason that there's going to be a disproportionate number of Muslim people who were caught up in these sweeps. And so based on that, the judge said, oh, so it's really just as likely that the NYPD was looking for terrorists, and they didn't really have any animus towards Muslims. Well, animus is not a requirement for constitutional protection. Even if the NYPD's activities were benevolent, the Equal Protection Clause still applies, and you still have to apply strict scrutiny. And here we have NYPD reports that actually say, yes, we're going into the Syrian community, but we're not interested in Syrian Jews. We're going into the Egyptian communities, but we're not actually interested in Coptic Christians. We're interested only in Muslims. So the facts are so much different than the precedent that the court relied upon, because here we have smoking gun evidence that the court was focused on Muslims. It wasn't like in the Supreme Court case where it kind of, quote, stands to reason that Muslims would be disproportionately impacted. So we really think that the trial court got it wrong on both of those bases, and those are the bases that we're going to the Third Circuit on.
Speaking of smoking guns, they didn't find any, did they?
No, that's exactly right. In one of the other cases I refer to, they took the deposition of a commanding officer, Thomas Galati, and they asked him, did this spying program produce any leads to criminal activity? And he said, no, not since I've been the commanding officer, and I'm not aware of any even before that. So I shudder to think how much money was spent on visiting every single Muslim establishment in New York City, Nassau, Suffolk, Newark, other parts of New Jersey, parts of Pennsylvania, parts of Connecticut, to not produce a single lead.
In some sense, I get the feeling that defending the program in light of that, after essentially more than a decade of spying on the Muslim community, is like trying to defend the idea that the earth is flat. There's no basis for the suspicion if trial and error shows that there is no activity to be monitored anyway.
I think that's right, but, we're not putting all of our eggs in that basket, and we don't want to rely so heavily on the fact that it didn't turn up a lead, because the activity was unconstitutional even if they had turned up a lead. Just like if police on Broadway in New York said, for every black driver that comes by, we're going to stop them, pop the trunk, and frisk them. And they do that. And then they say, oh, look, with this guy we got a gun. Oh, look, with this guy we got some illegal drugs. See? Racial profiling works. Isn't this a wonderful program? I think everyone would say, actually, it's still unconstitutional. You can't target people based on race, even if you turn up some evidence of criminal activity. So while it certainly, I think, makes the program look really bad, even if they did turn up a lead or two, as far as I'm concerned, that doesn't make the program any more constitutional.
In their court filings, the city and the NYPD maintained that the plaintiffs in this case, the Muslim communities, Center for Constitutional Rights and Muslim advocates, had conceded that the surveillance was constitutional. Is that what your filings said? No,
it's not. What the city said is that the surveillance itself is not inherently unconstitutional. And we acknowledge that, yeah, surveillance is not unconstitutional 100% of the time. Of course, surveillance has a legitimate place in the repertoire of law enforcement activities. Just like anything else, basically like shooting someone is not necessarily illegal if it's in self-defense. But that doesn't mean that if you shoot someone when it's not in self-defense, it's not illegal. So basically, our response to that was, yes, surveillance in general is not inherently unconstitutional. When you do surveillance based on race or religion or ethnicity or national origin or all of these constitutionally protected classes, an otherwise innocuous activity becomes unconstitutional. And that can apply to asking people, where are you headed today? If a police officer on the corner asks someone that, there's nothing illegal about that. If the police on the corner asks only the black people who walk by, where are you headed today, it becomes unconstitutional. And that's what we have here.
Glenn Katon is legal director of Muslim Advocates, based in San Francisco, California. This has been Left Voices for Friday, March 21st, 2014. Join us again next week for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.